the Speaker disqualified 21 people in the meantime. And the Deputy Speaker, with a session outside the precincts of the House, declared that to be void.
So the governor fixed the first item in the agenda as the removal of the Speaker.
Yes. And said that you cannot change the composition of the House. In the meantime, it had already been changed because the Speaker had already disqualified those 21. It is already changed.
Before 9th. Before
the 9th. So this then was the order of the Deputy Speaker, struck down by this court. The order of the governor preponing the session, struck down by this court. But more important than that, in the meantime, a new government had formed. Because these 14 members were declared to be continued to be members, they defected. A new government was formed. This time, this court, first time in the history of this court, in fact ensured a status quo ante and said, we will not tolerate this. Nabam Tuki became the chief minister for 2 days. And then somebody else, Khaliko Pul, he then defected and then he became chief minister. The point is, why did we have the 10th schedule? We had the 10th schedule to serve the cause of political morality and to ensure defections don't take place. And now this very 10th schedule is actually subverting that. There was a time when 356 was misused. And by all governments. Today, the 10th schedule is misused by all governments. That's where we are. So you have to decide, whether you want to uphold Kyoto or a whole new system has to be put in place if you want to really serve the cause. Now, there's another shenanigan happening. Before, when you defect, we know that they are defecting, so all of them go to the Speaker and resign, so that they should not be disqualified. Now, because they resign, then elections to take place, then they win, then they become ministers. That's another thing, Your Lordship, my Lordship, the Chief Justice has seen that happening, in Karnataka, saw that happening in Madhya Pradesh. This is the new thing that's happening. So how is this going to work? And how does a notice to a Speaker, deny him? Look at it another way. There may be several disqualification petitions pending against several members of several political parties. You may have a disqualification petition against a Samajwadi Party, a BSP person, a Congress person. So a Congress member, one MLA files a notice, he can't even decide the others. He can't deal with the Samajwadi Party or he can't deal with the BSP because he's disqualified.
Let us see those observations in this judgment.
I'm sorry?
Let us see those observations. Yes. Like the resolution was passed and the resolution was to be considered for the disqualification of a certain speaker.
In this case, a notice was issued.
Resolution was also, and it was directed.
A notice was issued, and on the basis of that notice, on the 27th, a writ petition was filed, 468 and 469. On the basis of that, it was stated that now that a notice has been issued, the Speaker can't deal with the matter. True, it was later, the resolution was passed. So, on that basis, and the other thing that happened, two things happened. One, they said that you can't deal with the matter. Two, the Speaker had given only 2 days notice to the MLAs. Second ground raised was that this 2 days is not enough. So, these are the two issues raised in writ petition 468 and 469. And on that basis, on the 27th of June, this court said that we give them 12 days, we give them till 12th of July to file their reply. In the meantime, the government was toppled.
Now let us see how they formulated that,
I'm just wanted, my Lord asked that question, so I just wanted to respond to that. Now, may I just point out here, they say through a notice of resolution. Actually, this is inaccurate language. It is a notice to move a resolution. It is not a notice of resolution. It is a notice to move a resolution for the removal of the Speaker. Because that resolution is moved only when the House gives leave. So this is completely inaccurate.
Under the proviso.
Yes, yes. But if these disqualified members are disqualified, then they would not be in majority. then this consequence would not happen.
Right.
The office of the Speaker with which the Constitution vests the authority to deal with disqualification petitions against MLAs must surely be a Speaker who enjoys the confidence of the Assembly. After all, disposal of the motion under 179C would take no time at all. Well, I don't understand this statement either. It can take 6 months. If you issue the notice, just after the session is over, and the next session is within 6 months, it takes 6 months. Which means there's a hiatus in the functioning of the constitutional authority. So how did the court say it will take no time at all? It will take no time at all if the leave is granted in the House and the resolution is put to vote. Then it's no time at all. So my argument before your lordships is going to be the following. Let me state that a notice for removal of the Speaker should only be moved when the House is in session. That will prevent all this malpractice that takes place. It's a proposition that my learned colleague Devdutt suggested to me, and I found it appropriate. Otherwise, what happens is that you can topple governments at your will, knowing the nature of our politics. But if it is allowed to be moved only when the House is in session, and if leave is granted and within 7 days it has to be put to vote, then none of this will happen. Then the 10th schedule will be allowed to function. And also the Speaker, when the resolution is passed, till such time as the resolution is passed, he continues to be a Speaker of the House. He only vacates his seat when the resolution is put to vote.
Otherwise, according to the consequences, the moment a notice of resolution is issued, he becomes disabled.
Yes.
And it's a constitutional office.
Yes, it's a constitutional office. There can be no hiatus. There can be no pause.
Rules of the legislative assemblies indicate how many members have to move a notice.
29.
29. All assemblies.
No, they're different. Rajya Sabha is different. Lok Sabha is
29 is the number under the rules.
Yes, under the rules of business.
So then
It's 10%. 10%.
where does the 10%?
Where do you get that?
Under the rules.
In the
Rule 11 says 29.
Oh,
Rule 11
different assemblies will have a different threshold.
Yes, every assembly will have.
every assembly would have a different.
There's no axle.
There's no
uniformity.
uniform. No. For example, in Rajya Sabha, in Lok Sabha, it's 50.
Oh,
Rule 20.
But notice can be given by one person.
Which rule is this? Rule number?
Rule 11. Rule 11.
The whole process, according to your submission should be completed in that session.
That's right.
No, the concern rule, you're answering your question. Concern rule is at page 40.
Page
Page 40, statute compilation. My learned friend is right. The figure used is 29, but the logic is 10% because the membership of this house is 288. So the nearest round.
So Rule 11 says 10%.
It's not notice, it is leave to move the resolution. Notice is by one person.
Correct. Unless it is supported by 29 MLAs, correct? It is not a resolution at all.
Yes. Not only that, but he may not move it.
And only
what has happened in this case, that resolution has never been passed. 8 months have passed. He only did it to ensure that the Speaker doesn't act under the 10th schedule. But today, let's talk of this case. That notice was never moved.
No, according to you, notice is never put to vote. Only the resolution is always put to vote.
No, notice may not be moved at all. You may issue a notice, one member, and the one member is common in every assembly rule. In every rules, in all rules of business, of all assemblies in this country, including parliament, one member can move. See the consequence of this. He may move and he may not move it when the session comes up. He may just drop it. Or he may not get leave.
So he may serve the notice even not when the legislature is not in session.
That's right. He may not serve when it's not in session. And see the consequences. And they are doing it in every case now. We also did it in this case, but that's the objection my learned friend told me. when we realized that he was going to disqualify us. Now, kindly see what has happened is, Mother, that the Speaker has only issued notice to us, that is the Congress, that the MVA, for the disqualification of their members. He has not even issued notice to them on our disqualification, till date. And then my learned friend's argument is, go to the Speaker and have it decided there. What is going to be decided? He's not even issued notice in our matter.
8 months.
8 months have passed. That's why I said on undisputed facts, Mullah's violation of the 10th schedule 2.1a and 2.1b is ex facie proof.
So really speaking, there are two thresholds. One is the 14-day notice.
Yes.
When you give the 14-day notice, the House doesn't have to be in session at all,
Yes, yes,
because it can be even before the House Assembly.
yes.
And once the 14-day notice is given, then Rule 11, which is at page 40 of the statute compilation mandates,
Yes.
that thereafter, not later than within a period of 7 days,
Yeah.
thereafter, he will request the members who support the notice to rise.
Yes.
And if more than 29 people support it, then leave is granted to move the motion for.
He may still not move it. He may still not move it, Mullah. It's only leave that's granted.
Right.
So member may not move it.
So, Mullah, what will happen is, Mullah, that it will be fixed in the House within 7 days as an item on the agenda, resolution of movement. Mullah, still such time, the resolution is actually, Speaker is conducting his affairs in the Assembly. He is not prohibited either under the Constitution or the rules of business not to sit in that chair, even though there is a motion, there is a notice, and there is leave. He only vacates his chair at the time of voting. So, whereas the Assembly goes on, but the 10th schedule is paused, constitutionally paused by this judgment.
And it is after leave is granted that the motion has to be then taken up within a period of 7 days.
That's right.
So the first threshold really, I was just reading Rule 11, says that the motion to remove the Speaker is to be given, of which 14 days notice is required under Article 179. That's the Article 179 threshold.
That's correct.
That is given. Then as soon as maybe after the expiry of that 14 days notice period, it would be read to the Assembly by the Speaker. The
Correct.
Speaker said, well, those who are in favor should rise. If 29 people rise, then leave is granted.
Yes.
And then within 7 days thereafter, a motion
Absolutely.
to remove the...
That's the process.
That's the process.
That's the process.
Part of it is constitutional, the 14 days requirement.
That's right.
But the rest of it is legislative assembly procedure. Of course, that's also rules made under the Constitution.
That's correct.
Now, Nebium says that the moment the notice is given by an individual,
Right.
you are then disabled. The Speaker is disabled from functioning.
As a tribunal, not otherwise in the Assembly.
He performs all his...
All his functions in the Assembly. So how can you have an interpretation of the Constitution where the Speaker against whom there is a notice for removal functions in the Assembly but can't function under the 10th schedule?
So according to you, at what point of time is the disability attached to the Speaker?
There is no disability.
There's no disability according to you.
No, there can't.
Even after the 29 threshold is crossed
Yeah.
and leave is granted to move a resolution,
Yeah.
according to you, there is no...
There can't be, Mother. Still can't be because the resolution may never be moved.
Unless the resolution is put to motion, put to vote.
Exactly. And Mother, the reason is why there cannot be no hiatus. Because Mother, there must be somebody in the tribunal to deal with disqualification petition. So you can't say that between the leave and the resolution he should not function. Because the Constitution doesn't allow a pause, Mothers, in the functioning of constitutional authorities.
Once leave is granted, Mr. Sibal, the discretion to move the motion is still with the member who is moving the motion.
Yes.
So he may not move the motion at all.
You do not move it.
Is it that after the leave is granted within certain days, the motion is to be moved?
7
Actually
days.
put?
7 days. 7 days.
7 days.
Suppose it is not moved by the concerned,
Doesn't matter.
it will lapse.
Absolutely not.
But if he stands by his motion,
Yeah.
the Speaker has no option but to move it listed within...
Then Article 181 says you must actually move from the chair, becoming the... Well, then what happens? Very interesting. The
Can
Constitution...
we just see, let's keep Nebam.
Yeah,
Let's look at the Constitution for a
Yes,
minute.
yes. 179.
It's always better to apply our
Always better. Always better. I agree. I always tell my colleagues, Malaj, lead the statute before you go to judgment.
So according to you, really the disability attaches to a removal.
Yes.
And until there is no removal, there is no disability. There is no constitution does not contemplate a hybrid situation.
Either as a Speaker of the Assembly or under the
Member.
bench.
Or under the 10th schedule.